kindly pardon to make a mention, my lord. I have filed one IA for conversion of criminal appeal to BL appeal, ma'am.
Give it.
Tomorrow.
Let's say one tired of bail matter.
Give it. Tired of bail matter. Earlier I have several memo but not listed. Give it.
Let's say press bail matter.
Pardon to make a mention, my lord. My lord, we have filed an IA for the early disposal of the case because the petitioner is a 83-year-old man and he and his family members totally depend upon his pension income. But the pensionary benefits has been stopped by the disbursing authority. Kindly list this matter.
Give it.
Tired of number of 5 years of corporate main act is already released on bail.
Give it.
My lord, may I mention one BAPL number 12096 of 2023. My lord, on last date of hearing on 18 December 2023, my lord had directed to list this matter on week commencing 18th January, but the matter is still not listed, my lord.
Noted down. Yes.
My lord, this week.
We'll see that, yes.
Supplemental list, item number 1.
Person convicted under section 306A
rupees 3,000 for under the offence of section 7 of the PC Act and 5 years 5,000 fine under section 13(2) of the PC Act read with 13(1)(d) of the PC Act.
You were on bail during trial?
Yes, my lord. I was on bail during trial.
Yes, Mr. Das, you have received copy?
Yes, my lord. I'll file my appearance memo by the end of June, my lord.
Admit court for the trial court record. He was on bail and after conviction he has been taken into custody. So bail allowed. Stay realization of fine. Mr. Sanjay Kumar Das, Learned Standing Counsel for the Vigilance Department, submits that he will file his appearance memo, so on so. Name be reflected in the cause list. Free copy of the order be handed over to the Learned Standing Counsel. Yes.
Grateful, madam.
Item 5.
May it please court. Your lordship, this is an appeal against conviction under section 31D read with 13(2) of the PC Act and 462, 471, 420 and 120B of IPC. The sentencing part is at
What is the maximum sentence imposed?
the 3 years.
3 years. It's a concurrent sentences.
Yes, sir.
Okay. What is your good name?
Amit Vikramacharya.
Huh?
Amit Vikramacharya.
Give your full name in a slip. Okay.
Sir.
Admit he was on bail. Bail granted. Stay realization of fine. You are on bail during trial.
My lord, this matter,
Yes.
co-appellants by the CRLA number 157 of 2024, 162 of 2024. Your lordship have already admitted on 5/3/2024.
What is the two numbers you said, Mr. Das?
3 numbers. CRLA 157 of 2024.
Yes.
162 of 2024.
Yes.
Both these were admitted by your lordship on 5/3. On 12/3, your lordship have admitted CRLA number 191 of 2024.
All right, Mr. Sanjay Kumar Das, बाकी से जो लिखी देवे से file किया appearance में हो. He further submits that this matter is connected to CRLA number 157 of 24, 162 of 24, and 191 of 24. Henceforth, the matter shall be listed. This matter shall be listed along with so and so. Name of Mr. Das be reflected in the cause list. Free copy of the order be handed over to Mr. Das. Yes.
Item 6.
May it please the court.
Yes.
Lordship, this is also an appeal against conviction under section 13(2) read with 13(1)(d) of the PC Act and 7 of the PC Act.
What is the maximum sentence imposed?
See, the sentencing part in your lordship is that
Yes.
2 years.
2 years. Is it a concurrent sentence or consecutive concurrent sentence? And you are on bail during trial?
Yes, your lordship.
Yes, Mr. Das.
Yes, I have already received.
All right. Admit. Is there any connected matter, Mr. Das?
No, my lord. Single matter, single accused.
Admit, bail granted, stay fine. Rest of the thing like the previous matter. Yes.
And also free copy to given.
This is all these matters. Yes.
Keep
Next.
the
My lord, I may be pardoned to submit before your lordship that your one matter has been listed before your lordship's court on item number 75. Your lordship directed the Lord Counsel at Koraput to serve the copy of the delay condonation petition. I have not received the same.
All right, when
No
the matter
copy has
reaches,
been
we'll see that. Okay. Yes. Call
No
the-
copy has been served, my lord.
Item 7.
Yes, item 7, Mr. Joshi. What is this matter, Mr. Das?
RI 10 years, my lord.
Item 8.
Yes, 8, 9 you give 9 रे delay condon होगा, है
Copy
बाकी
भी हमको दिया से.
copy दे देवे और जो usual order हुए advocates engaged intimate to the appellant. Yes, next.
Item 10.
You have received the case diary.
My lord.
It's a CST matter.
302 3 assist.
Notice sufficient.
My lord, notice. A notice is not received, my lord. Let you next notice to asini information. We have already sent
Because it was issued on 16/2/2024.
Must have
And you have also you said on the other day that you did not receive the case diary and also the instruction about this criminal antecedent. Now you have received the case diary, and so only thing is that notice. All right. None appears for the appellant. Land counsel for the state submits that he has received the case diary. So also instruction about the criminal antecedent against the appellant. However, he is yet to get the confirmation letter regarding service of notice on the informant. The matter may be taken up next week. Put up this matter we commencing from a week after Purjandu. We commencing from 2nd of April 2024.
Item 11.
May I please, ma'am? 3 SCST appeal, my lord.
Who is appearing for the informant,
Yes.
Mr.
I am appealing.
Okay.
My lord, offenses under which
You have received the case diary
My lord.
and also
offenses.
instruction about the criminal antecedent.
No, my lord. No antecedent.
No antecedent.
My lord, the appellant was taken to custody on 12/10/2023.
Last occasion, my lord, directed to receive the photographs of the injured, my lord.
Let me see.
Last order of my lord. 30% injury is there.
Land counsel for the 6 for an adjournment, then land so confirmation regarding it.
Has already been discharged.
Submitted notice of so has been made sufficient. Now
Discharge since
6 for an adjournment. Who order Richla? What is the order dated 11/3?
my lord.
So also place the statement of injured Jitan Kumar Soren, from which it revealed that he sustained burn injury due to overt act committed by the appellant and his friends on 8/10/2023. Statement has been recorded on 19/10/23. State on verification of the case record submitted, injured has sustained 30% burn injury. Let the land counsel for the state obtain the photographs of the affected parcel. So what happened? No, it's dangerous. So what happened to the plastic surgery?
That
Plastic surgery, my lord, he has undergone plastic surgery and
No,
discharged. His condition was satisfactory.
So you take steps for the plastic surgery. I'm not granting bail at this moment. After looking at the photographs and going through the statement of the victim and the injury report, I am not inclined to release the petitioner on bail. Petitioner may renew the prayer for bail after the charge is framed. Appellant, yes. Next.
Lordship may adjourn to some other time.
Yes, it's not.
Item
Next,
12.
12.
May I please, Your Lordship? The notice has been issued, and last time it was the submission of the State Council that notice has been served.
Yes.
my lord. Notice or my lord.
When can you give
4-3.
4/3? Okay, so at least 2 weeks have passed.
My lord.
Yes. You can make your submission.
Yes,
Here, my lord, receive the CD.
Yeah.
Let me give some time. Any other day.
Your Lordship,
You want
Your
to go
Lordship.
through it? So tomorrow, day after tomorrow,
Any day.
day after tomorrow. Put up this and counsel for the state submits that notice on the informant has been made sufficient on 4th March 2024, and he has also received the case diary, but the matter may be taken up day after tomorrow. Put up this matter on 20th of March 2024. Yes.
Item 13.
13, my lord, I'm praying next.
You have got the case diary
13, my lord. My lord.
and notice sufficient.
My lord. Do ek, my lord.
Land counsel kete kebe
Do ek.
Okay. Land counsel for the state submits that notice on the informant has been made sufficient since 2/1/2024, and he has also received the case diary. Land counsel for the appellant seeks for an adjournment. List this matter in the we commencing from 2nd April 2024. Yes.
Item 14.
Lord, SC/ST
Item 21.
May I proceed? Last occasion, Lordship called for the social investigation report.
Yes, Mr. Tripathi.
The social investigation report received,
Yes,
but
and
the CD is not available.
what is the offense here?
20B2C, petitioner is a juvenile.
All right, to get the case diary.
Yes, ma'am.
So 2nd April 2024, he submits that he has received the social investigation report, but not the case diary. Yeah? 6 some time, 2nd April 2024.
Case
Yes.
diary may be available in another
Give
bail
the number,
application. I'm
give the
giving
number.
the number.
Mr. Tripathi,
Yes, ma'am.
take the number and verify if it is available.
Maybe.
Yes.
Was here early.
Item 22.
Yes,
May I please, ma'am? Well,
Item 25.
25 confirmation report not receiving notice.
You have received the case diary?
No,
Huh?
that is also not received.
CDCA and confirmation letter.
Yes.
So nothing you have received.
No.
So get it next week.
Next.
Huh? Land Council for the State 6 for an adjournment to obtain the CDCA and confirmation letter regarding service of notice. Put up this matter. Yes, next.
Item 26.
Yes, Mr. Dwivedi.
Yes, ma'am. Praying for next week.
Next week. You have received the case diary?
Yes, ma'am.
CDCA and notice sufficient.
I'm appearing.
You are appearing. Where is your vinama? File it. Mr. Prashant Kumar Rautray, Land Council files power for the informant. This Ashok Behra is the informant.
Yes.
Which is taken on record with a memo, which is taken on record. Land Council for the state submits that CD and CA are available with him. Land Council for the appellant 6 for an adjournment. Put up this matter. Give adjournment. Yes, next.
Item 27.
May please allow.
Item 28.
Yes. CD available?
CD available confirmation letter of notice.
Who stays Jaitala?
Conjanagar. Yes.
କେବେ ପଠେଇଥିଲେ କି?
ଆଚ୍ଛା ମତେ ଲେଖିକି ଜଣେ ମୁଁ କେମିତି ଜାଣି 13/3 ପଠାଇଥିଲି।
13/3 ମାନେ ଆସିନଥିବ।
My lord, I have instruction that informant and injured person absconded.
No, report should come to that effect unless Legono. Land Council, item number 28. Land Council for the state submits that he has received the case diary, so also instruction about the criminal antecedent.
Apart from that, this petitioner have 5 criminal antecedents.
Acha. The first one also good.
Also good.
Acha. However, the sufficiency, instruction about sufficiency of service of notice on the informant is awaited. Stop. Land Council for the state on verification of the case diary submit that there are 5 criminal antecedents against the appellant. Let the Land Council for the appellant obtain instruction regarding the status of such cases and file a comprehensive affidavit to that effect. You take the numbers of those
My lord,
5
I have
cases.
obtained the certified copy of bail order.
Whatever you file with an affidavit, give that. In this case, he has been released on bail. This case, he has been acquitted. Whatever you want to say, submit. Giving copy to the state council. Put up this matter on such and such date. Land Council for the state will produce the confirmation letter regarding service of notice. And the connected item is there
two antecedents.
Same. তাদের খালি 5 আর 2 করে দিয়ন্তু বাকি সব সমান করে দেবেন না? Yes.
Item 29.
My lord, if you notice to the
Yes, what happened? For the informant, his binama shall be placed on record and name shall be reflected in the cause list. Yes.
Item 30.
So, Mr. Das, my lord, can you pass over?
no, CD and confirmation of notice not received.
Awaited.
Yeah.
All right. CD and CA is to be obtained as stated by the Land Council for the state. Put up this matter. Do we commencing from 2nd April 2024? Yes.
Okay.
Item 31.
May I please, your lordship?
Yes, Mr. Tripathi.
Yes, my lord.
What about CD, CA and notice?
Notice sufficient, but
Kebe?
date not mentioned.
କେବେ ପାଇଲେ ଆପଣ?
এটা କାଲି ମୁଁ WhatsApp ରେ ବାହାର କରିଛି।
And case diary you have received?
Yes.
So why didn't you ascertain if the date is not there? You can give a ring to that person and ascertain, because we are giving 1 week time
Yes.
to the informant to make appearance. So if he has received the notice, let us say on 15th, so how can he contact the London Council and
Let it come next week.
no, if you You can, when did you send that notice to him?
5/3
So suppose notice is there on 7th, 8th, so it can be taken off. I'm keeping this matter on 20th.
yes ma'am.
Better you will depend upon whether we'll further adjourn or hear the matter. Okay. The Learned Counsel for the state submits that notice on the informant has been made sufficient, but the date has not been given, and the matter may be taken off on day after tomorrow in order to ascertain the date of service of notice. However, he has stated that he has received the case diary as well as the instruction about the criminal antecedent. Put up this matter on 20th March 2024. Yes.
Item 32.
Yes, Mr. Jena.
May please, your lordship.
Yes, CDCA
yes ma'am.
and notice.
Notice 13/3/24.
Okay, do. Yes.
Milord. May please, your lordship.
Just a minute. What is the date of custody?
Milord, 8/12/2023.
And what are the offenses under which charge sheet submitted?
Hence, Milord, 147, 148, 149, 323, 325, 326, 307, 335, 302 IPC, Red Section Milord, 3 SCST Act Milord.
In
Case
this
of
case,
construction, Milord.
charge sheet not yet filed.
That no instruction I have instruction.
Then you have to wait. Kebe to galani vitru.
Milord, case the present petition appellant is in victimized in circumstances, Milord. He
That's
is
all right, but 302.
8/12/2023, Milord.
812, Mr. Our 120 दिन हले. Few days are left, so let us keep it on 8 and
Yes ma'am.
take as Learned Counsel for the state submits that he has received the case diary, but he may be given some time to obtain instruction whether charge sheet has been submitted or not. Put up this matter on 8th April 2024. Yes.
Item 33.
Yes,
May
it
I
is.
please, your lordships. Last occasion, your
Acha,
lordship.
along with SUSA you connected matter. CRLA number 152 of 2020. Yes.
Your lordships, on last occasion, lordships, the notice was issued to the informant.
What happened to the
Notice served on 12/3/24.
12/3/19
Today, my lord, I appeared.
Acha.
And my lord, I have instruction also, my lord, forwarding report reveals that the appellant number 2 has 8 cases. And other one is, my lord, 6 cases. I have to file objection affidavit to 4 to 5 days next Monday, my lord.
So have you got any instruction about that? That there are number of criminal antecedents?
Your lordships, as per my instructions, petitioner number 2 is having 9 antecedents and petitioner number 1 is having 1 antecedent. That is there in the rejection
No,
copy
he said
itself.
that it is 8 and something 6 or 7. So if you have got the numbers of those cases, furnish him. So
Forwarding report
forwarding report रे अच्छी बोली कहउछंती तो सेही basis रे instruction नहीं जानती.
Your lordships.
Rejection order रे कौन लिखा है the matter is different, but if it is there in the forwarding report, then it is an authentic one.
Your
To
lordships.
get the instruction about the status of those cases,
Your lordships.
and you have received the case
Yes.
diary. All right, Land Council, Mr. Amulya Panda, Land Council appears for the informant, files Bhinama, which is taken on record. Land Council for the state has received the case diary. It is stated by the Land Council for the informant that there are number of criminal antecedents against both the appellants. Land Council for the appellant also submits that the forwarding report indicates about the same, and he will obtain instruction about the status of those cases and file a comprehensive affidavit to that effect. Put up this matter on the week commencing. केते दिन दरकार आपनको?
As your lordship pleases.
No. Suppose in one case he has been acquitted, you have to file, take the averment and get the acquittal order. If it is on bail, so you have to annex the bail order copy. So It is up to you how much time you require for this filing.
Your lordship, this may kindly be taken up next week.
All right, put up this matter in the week commencing from 2nd April 2024. Yes.
Obliged, lordship.
Item 34.
Last occasion on 5/3/24, your lordship was kind enough to issue notice to the informer.
Confirmation letter and CD not issued.
What is the offense here?
My lord, offense is my lord, 147, 148, 302, 320.
302 is there.
Yes, sir.
Run counsel for the state 6 for an adjournment to get the confirmation letter regarding service of notice on the informant, so also the case diary. Put up this matter on 2nd April 2024.
My lord.
Item 35.
May I please, your lordship?
Counsel enters appearance, but use your order.
Item 36.
May I please, your lordship, my
Yes, Mr. So,
petitioner is a assistant public prosecutor in Borden Court, my lord.
written proof for regarding service of notices.
Yes, I have entered my appearance yesterday. I have filed the wakalatnama in the box, but I have kept the xerox.
You have received the appeal memo, etc.
Appeal memo not received, but FIR and other things I have
So
informed.
there is no problem. We can argue the matter.
My lord.
We call for that VNAMA which has been filed for the registry. Yes. So what is this
My lord,
case?
307, and I have given the certified copy of the injury report, my lord.
Who is the petitioner?
Petitioner is Gautam Kwan Nial, my lord, APP in Borden Court, and the assistant public prosecutor, my lord. And he is the sarpanch of the husband of the local sarpanch, against whom the informant's daughter-in-law.
Petitioner is an advocate and is a public prosecutor.
Assistant public prosecutor.
So why he is doing all these things? 307.
He is the husband of the local sarpanch, against whom the daughter-in-law of the informant was contesting, and she lost the.
So whom this petitioner has assaulted as per the prosecution?
Against me allegation is I was only instigating. Instigating. My FIR, page 16.
Yes.
It was 10th line. ଏହିପରି ଘଟଣାକ୍ରମେ ଓ ସରପଞ୍ଚ ତଥା ସରକାରୀ ଓକିଲ ଗୌତମ କୁମାର ନିଆଲି ଉସୁକାଇବାରେ ଫଳରେ ଜାତୀୟ ଘୃଣା ସହ ମତେ ଠେଙ୍ଗା ବାଡ଼ି ମାଡ଼ପିଟି କରିବାର ଉଦ୍ୟମ କରିଥିଲେ ଏବଂ ମହିଳାମାନଙ୍କୁ
କୋର୍ଟ କାମ ଦାମ ଛାଡ଼ିକି ସେଠି ଯାଇକିନି କାହିଁକି ଏସବୁ କରୁଛନ୍ତି? You are a government advocate and public prosecutor. So how many cases are there against this man?
Same incidents I would have FIR. I have given the copy, my lord.
And
who accused person arrested?
Who were assaulted and what are the injuries sustained?
Injury given, my lord. Certified copy, my lord. All are simple, my lord. First one is the bail order of the another co-accused granted by London court, trial court, my lord.
Yes, Mr.
All the injury are simple, my lord.
What do you
one
say?
thing, my lord. Most of my instruction is concerned. One of the injured is in between died. She has supplied me the death certificate.
कौन ना कौन कहले?
That is in the rejection order. my lord.
Ghoradei Horizon. GHARADEI Ghoradei Horizon.
बाग ଲେଖା ହେଇଛି ଘରଟେ ବାଗ ଲେଖା ହେଇଛି.
ଏଥିରେ certificate ଟା ଅଛି sex female. ମତେ ଗୋଟେ copy of the death certificate they have supplied.
No, whether the case has turned to one under section 302 thereafter, because if it is not related to that incident,
I mean, law and government can say whether it has been
Mr. Tripathi,
I have no instruction.
because it's all right. Because the injuries are it appears one abrasion is there,
Yes, and
and the
laceration.
another is the split laceration, and those are simple in nature. So suppose that person has died for some other reason, so it is not
Maybe due
necessarily
to old age. She is
no
80 years old.
80 years age. That is the. So just take instruction whether the case has turned to one under section 302 or not. All right. वकालतनामा कहाँ नारे अछि जोटा फाइल करछिने
बेलामती बाग.
No, advocate को ना
विक्रम चंद्र घड़े.
आउ के ना अछि कि ना जणो को ना
मो ना अछि
आउ ना
आरबी मिश्र को थाई मो आसो.
file the copy let us see. So it can be just you can take instruction
Yes,
over phone. We can be taken up
Yes.
day after tomorrow. All right, Mr. Bikram Chandra Ghadil and counsel submit that he has he has filed Vinama for the informant before the registry. Let the Vinama be placed on record and the name of the London counsel for the informant be reflected in the cause list henceforth. During course of argument, when Mr. Mishra and counsel appearing for the apparent submitted that all the injured persons have sustained simple injuries, which is not disputed by the Land Council for the state looking at the injury reports, the Land Council for the informant submitted that one of the injured, namely Ghordei Bag, has died and he has got some documentary proof to that effect. In view of such submission, let the Land Council for the state obtain instruction as to whether the case has turned to one under section 302 of the Indian Penal Code or not. Put up this matter on 20th of March 2024, indicating the name of this one. So these are the certified copy of the injury reports and bail orders filed by the Land Council for the appellant, which are taken on record.
May I submit one thing, my lord? But that death took place on 21/1 and I was forwarded on 15/2, my lord.
I don't
Yes,
just an intimation
Absolutely.
whether it has turned to or not. Yes, next.
My lord, 21 posted.
20 तारिख दिन आसीबो
Tomorrow.
कोरी बुझिबे. Yes.
Oblige.
Item 37.
May I please? Last occasion notice was gone by.
कौन है
Confirmation letter and CD not.
To get it 1 week time, I'm giving. 6 some time to obtain instruction about the confirmation letter regarding service of notice and case diary. Put up this matter on such and such. That yes, next.
May I submit, my lord? Earlier, the appellant was appeared this court in CRL number 1110 of 2023, and liberty was granted to move after examination of the injured person. Till yet, charge has not been found, my lord. Kindly
All
call
right,
for a report.
the London Council for the appellant submits that the earlier bail application of the appellant in CRL number 1110 of 2023 was rejected as per order dated 29/11/2023, and liberty was granted to the petitioner to renew the prayer for bail after examination of the injured in the trial court. Land Council further submits that till date no charge has been framed. Status report be called for. Yes.
Oblige.
Item 38.
May I please issue lot similar fresh matter notice is required to, my lord.
Okay. fresh matter notice ଆପଣ ଦିଅନ୍ତୁ copy ଦେଇଦେବେ ବାକି CDCA confirmation letter
Item 39.
My lords, 39 days delay.
fresh matter
My lords.
all right same order. This notice has to go on limitation matter because there is a delay of 39 days. So you serve an extra copy of both the criminal appeal memo, so also the interim application, right? All right, CDCA be obtained karibe, extra copy. Yes.
Item 40.
Fresh matter, my lord. Fresh criminal.
All right, extra copy you serve, huh? CDCA confirmation letter.
Item 41.
It urgent matter, na?
Maybe. Last page, I will directed to take instruction.
When counsel for the state submitted notice 8 upon TSC please. Informant on 11th March 2024 and he is yet to receive the case diary. So also the social investigation report. Notice sufficient age 11th March 2024. Have you received the case diary?
No, my lord. Case diary and
Social investigation report. So get it 1 week time. I'm granting to you. 6 for an further adjournment to get the case diary and social investigation report. Yes, next.
Charge sheet submitted, madam.
It's all right. You have got the copy of charge sheet.
Item 47.
My lord, in this case, your lordship, on last occasion, 47. Is that 47? Sorry.
May I please, Your Lordship?
Yeah.
Lordship, this is the second journey of the petitioner.
Hmm.
The offense under section 302,
Just
along
a
with
minute,
other allied.
let me see why it was adjourned on the Learned
Lord,
counsel for the submit that earlier bail application of the petition was rejected and so on so, and he has filed the rejection which is taken on record. Okay.
on the last occasion, my learned senior's bail application was tagged up with this.
Okay, that's all right. You have received the case diary, Mr. Tripathi.
Yes, and as well as deposition copy of some witnesses.
Okay. So how many witnesses have been
My
examined?
lord, out of 32 charge sheet witnesses, 8 witnesses have been examined. Material witnesses have been examined.
So what is the date of custody?
My lord, 6/7/2020.
7/7.
7/7/20
2020.
2020 এটা হচ্ছে appellant number appellant রাঘবর.
Yes, ma'am.
So what about Manoj?
My lord, I'm in custody since 26/12/2023.
26/12/2023.
Again.
And what are the offences under which charge sheet submitted?
147, 148, 341.
Just go slowly.
My lords.
147, 148,
341, 294,
341, 294.
506,
Yes.
302 by 149 IPC, read with 25 amps act.
What is the name of the deceased?
What's the
My
name?
lord,
Rajendra Rao.
Rajendra Rao.
Raut.
Rao?
ROUT. Raut.
Raut, acha. ROUT. And date of occurrence is?
That's the date of occurrence is on 27/5/2020 at 3 o'clock in the afternoon.
27/5/2020.
Again. FIR was on offense branch.
Is there any eyewitness to the occurrence?
Yes, ma'am.
Yes.
356 are eyewitness.
So they have been examined in the trial
Yes,
court.
yes.
What they have stated?
Omnibussly stated, for which your lordship, if your
So
lordship
let us see, come to PW3 is one of the,
Eyewitness.
I'm the informant in this case. The deceased is my younger brother. I know both the accused persons standing in the dock. I also know the other culprits in the case. Occurrence took place on such and such date. As my younger brother was ill, so I took him to on my way just before so near. At that time, accused Dilip Maharana with a sword in his hand, Ranjan Sahu with a sword in his hand, Manoj Bera and so on. So, along with so and so, came to us, restrained our vehicle. All after restraining me, abused my younger brother, so and so. Then they dealt blows, pushes me, they dragged Rajendra to a nearby castle jungle. But they all take off. So names of all these persons find place.
Yes, my lords. Your lordship may kindly have a glance to annexure 4 and 5 series of my brief BLAPL 316, wherein your lordship was of the view in annexure 4, that is the bail order of one Dilip Maharana, page 46. Last parameters. Let's may read it, top 7 lines. Learned counsel further submitted that in the meantime, has your lordship got it? Learned counsel further submitted that in the meantime, 6 witnesses have been examined and most of them are eyewitnesses to the occurrence, and they have stated in an omnibus manner about the participation of 20 to 25 persons, including the petitioner, in assault of the deceased Rajendra Rao by sharp cutting weapons vis-a-vis sword, farsa, bhujali, koturi. However, the postmortem report indicates that there are only 8 external injuries found on the person of the deceased, which creates doubt about the participation of so many persons in the assaults of the deceased. He further submitted that in view of the progress of the trial and the conduct
My lords, your lordship was pleased to grant bail. Similarly, my lords, if your lordship will glance annexure 5 to my brief.
No, this person, this name of this man is Dilip Maharana alias Tutu. Has he been named by that eyewitness PW3?
Yes, my lords.
So any difference between this man? All right. And common order कर देवे. Land counsel for the petitioner Raghava Sahu submits that the petitioner is in judicial custody since 7/7/2020, and the petitioner Manoj Behra is in judicial custody since 26/12/2023, and they have been charge sheeted under section 147, 148, 341, 294, 506, 302, 149 of the Indian Penal Code, and section 25 of the Arms Act. The occurrence in question took place on 27/5/2020. FIR was lodged on 28/5/2020, and the deceased is one Rajendra Rao. In the meantime, in the trial court, out of 32 charge sheet witnesses, 8 witnesses have been examined. Land counsel for the petitioners placed the bail order of co-accused Dilip Kumar Maharana alias Tutu, passed in BLAPL number 13106 of 2022, by order dated 7/7/2023, and submits that the petitioners are similarly situated like the co-accused who has been granted bail. Learned counsel for the state place the evidence of the eyewitnesses who have been examined in the trial court as PW 3, 5, and 6, and fairly submits that as per their evidence, the petitioners are similarly situated like the co-accused Dilip Kumar Maharana alias Tutu. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, the nature of evidence adduced during trial, the release of the co-accused on bail. I'm inclined to release the petitioners on bail. Allowed.
Disposal.
Next.
Disposal.
Yes, both allowed. Yes, next. Item 48.
Grateful notes. Please, your
The bond
lordship.
for
Item 48.
Wait, please, my lord. This is the third journey of the petitioner, my lords, and have been in custody since 25/5/2018.
when it was last rejected?
It was last rejected by order dated. My lords was pleased to grant me interim bails on twice occasions. One is in BLAPL number 1022 of 2021 for a period of 4 months. That is by order dated 16/11/2021. My lords was pleased to grant me interim bail on twice occasions. One is wide BLAPL number 1022 of 2021 by order dated 16/11/2021.
Where is that order?
That is it.
(16/11).
Again.
But then the matter was disposed of on.
Yes, my lords. It was subsequently disposed of. Then I filed another BLAPL, that is BLAPL number 3722 of 2022, where your lordship was
Wait.
pleased to grant me another 4 months.
Just a minute.
Yeah.
Okay, so twice you are granted interim bail.
Yes, my lords.
For 3 months.
4 months each.
4 months on each of it.
And subsequently, on the last occasion, it was extended for 2 more months by an interim application, that is in BLAPL 3722 of 2022.
So now what is the position?
Milords, out of 152 charge sheeted witnesses,
Hmm.
12 have been examined. The last date was yesterday, Milords.
You were first time taken into custody when?
25/5/18. I'm finding the order sheet of the court below. Certified.
25/5/2018 you were taken into custody. When the charge was framed?
Milords, the charge was framed on 26/12/2018.
So, Mr. Naik,
Yes, Your Lordships.
charge was framed on 26/12/2018.
Yes.
So 5 years and 2 months
Yes.
at least have passed.
Yes.
And you have given a list of 152 charge sheet witnesses, and during the span of 5 years, 2 months, you have examined only 12 witnesses.
Your Lordships, may allow me to argue. First of all, Your Lordships, if Your Lordships will kindly come to the charge sheet for a moment.
Yes.
In this charge sheet, Your Lordships, in page 10 and page 17. Page 10 and page 17 of the charge sheet. I would like to read, Your Lordships. Investigation further revealed that the efforts were made by Orissa police to track the absconding accused, Amit Agarwal, son of Sri Madhav.
Mr. Forget about the absconding accused.
6 years he himself absconded, Your Lordships.
Charge was framed. That means everything so far as these accused persons are concerned.
Yes.
So you are supposed to produce the witness.
Your Lordship,
26.
I'm answering that. I'm coming to it. I'm coming to it. Your Lordship says CRLMP 525 of 2022.
Yeah.
CRLMP number 525 of 2022. The court master can take it out because just now I got a message. It was filed by the informant, Your Lordships, who was originally given the affair. His name is Abhishek Agarwal. The court master can take it out, otherwise I can message her also. CRLMP number 525 of 2022, Your Lordships.
525.
Yes. In that 520, this argument has been taken care of by another bench, Your Lordships. Honorable Justice Mr. C.R. Das has passed an order in which he had the same grievance about the delaying the trial. That has been taken care of by a judicial order which is in paragraph 4, Your Lordships. If the court master can take it out.
That CRLMP.
Yes. And when the first, Your Lordships, I will also tell and argue the reasoning behind the interim bail, Your Lordships. Why Your Lordships had granted interim bail at that point of time.
A special agency headed by the officer not below the rank to monitor the case, identify the material witnesses. If necessary, question is made. Who are the material?
Therefore, the petitioner has to move before the trial court. I don't know whether he has moved or not.
It's all right. You have given an undertaking that is all right. That order was passed just now on 22/2/2024.
Now, Your Lordship, for a moment, Lordship, there is also some miscommunication. I would like to, because when initially Your Lordship will remember this matter was listed on Mr. Sori Chandra Mahapatra, senior advocate, was arguing the matter. So when he started the arguments on merits, Your Lordship said that there is no question of regular bail, interim bail I may consider. After that, Your Lordship, when it was extended, would like to take that order, Your Lordships. Lordship, they have filed a bail application. If Your Lordship has a copy of that bail application, bail application number 387, Your Lordships.
387.
And another bail application, Your Lordship, was that bail application number 8646. In 8646, Your Lordships, some of the deposition copies were given, Your Lordships. Examination, cross-examination, everything is mentioned. Now, if Your Lordships will come to order dated 21/3/2023 for a moment. On that date, Your Lordships, interim bail was granted not because for the long period of incarnation or on merits, Your Lordships. At that point of time, Your Lordships, an argument was made to which my statement is also recorded. Your Lordship may kindly come to page 2 of the order dated 21/3/2023 in bail application number 3722 of 2022, Your Lordships. It is a miscommunication, your lordships, on both sides. Here, your lordships, in bail application number 8646 of 2023, deposition copies are there. Now, your lordships, if your lordships will come to the order, in order one argument was made, this court may read, your lordships, you have that order.
My lords, I have supplied a copy.
No, that is the operative part is that since the CBI has not come forward with any case that during the interim bail period there was any kind of
No, not that. So, lordship, order dated 21/3/2023. The reasoning behind giving the interim bail, your lordships.
2023, I am reading.
At
That
page 2, your lordships. Permission was sought during the course of argument to withdraw. The said disposal was withdrawn. Mr. Panda pointing out from the order sheets of the learned trial court submitted that on 30/11/2022, the learned trial court found that 161 statement of the witnesses are not available in the case record, and the learned counsel for the CBI submitted that the statements are in Calcutta. At that point of time, your lordship, the IO told me over telephone. Your lordships asked me, if you remember, that kindly ask the IO where are the 161 statements. And if you not produce the 161 statements, how they are going to trial is going to continue, and he's there for 5 years.
Yes.
Then lordships, if the 161 statements were not with the learned judge, with due respect, then how could he examine and cross-examine 7 to 8 witnesses? It is not a case that half of the witnesses we had given him and half was not there.
You made a submission that has been recorded there.
Yes, but
no, I'm not. I'm just.
I'm admitting your lordships, but I could found out. I went and searched the record myself. All the copies were given at that point of time.
It's all right. Now the question is that there is no the delay that has occurred. The petitioner is not responsible for that. That is what I am pointing out to you. That
I respectfully agree to it, but for the first 6 years when he absconded, he was responsible.
That is there, but after the charge was framed, during the span of 5 years, you have examined only 12 witnesses. So that is the reason why I am asking you that
now, your lordship, that can be taken care of.
CBI is filing a charge sheet, so huge number of witnesses. After charge is framed, only 12 witnesses is examined during the span of 5 years.
That is a fact, your lordships, that cannot be taken away, but that has been taken care of, even though this year.
Given undertaking before the court, that is all right, but thing is that.
Your lordships may kindly come to the merits of the case also for a moment.
I am not on merit, I am questioning because merit it has already been rejected. There is, and he has been granted also interim bail, and you have not submitted anything that he has misutilized the liberty during the interim bail period.
But your lordships, this murder, your lordships, is a, with due respect, your lordships, this is one of the most bastardic, diabolic, semi-barbaric, inhuman, brutal.
That is
completely
all right, but that does
two
not
minor child, your lordship,
you will take 20 years for concluding the trial and detain the man petitioner.
Two minor child, one pregnant wife, the child was there inside the womb, brutally murdered, left, went absconded for 5-6 years and gave an extrajudicial confession that I had done so.
Like, what will happen in the ultimately, whether he will be hanged, will be sentenced to life imprisonment, those are the things. But why
let him move that application under 5 the order which is
why you are not speeding up the trial, and why the person would remain for 5 years and you will just examine 5 years after framing charge, you will examine only 12 witnesses.
We are ready with your lordships. I can make twofold submissions, your lordships.
Yeah.
Lordship, may kindly bear for a moment. Lordship, the prerogative of the trial is of the trial court. As far as we are concerned, your lordships, we are ready and willing. We will not seek any adjournment. We'll bring the witnesses on time.
So, you mean to say that on each date you have produced one witness or at least 2 witnesses? The order sheet reflects otherwise. The certified copy of the order sheet which is producing, it indicates that you are not producing the, there is no fault on the part of the, because they are UTP and even they are, even if they were on interim bail, they were, but each date you will find that no PW present, no PW present. In this way, the case has been adjourned from time to time. At least he's produced the order sheet from 13/10/23. And thereafter, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 dates. And on each occasion, the UTPs are there produced through VC, but no PWs present, the case is adjourned. Only one date, that is on 18/1/24, perhaps, yes, one witness, Tarun Kumar Saxena, that was examined on that day, that's all. So this is the conduct on all these
So
dates.
we'll file an affidavit. We'll file an affidavit. Will abide by any of the
No,
conditions.
affidavit, this is the matter of record. How
But
you
with much difficulty, your lordship, is an
you are
outsider.
supposed to produce the prosecution witnesses. CBI,
Lordship,
if it is CBI fails to produce the prosecution witnesses on number of dates and the only produce 12 witnesses in the span of 5 years after framing of the charge, and claim that it is a serious offense, heinous offense. Yes, you conclude the trial, let the trial court convict him, decide the case on whether he will be sentenced or acquitted or sentenced to hang. That's a different matter.
your lordship, as in many cases, your lordship passes an order in these kind of offences. Your lordships will provide a list of the witnesses who are material witnesses who could be examined first, and your lordships may target it and will be abiding by any of the
Learned
conditions.
counsel for the petitioner, learned counsel, Mr. Sarthak Naik, learned special public prosecutor. The learned counsel for the petitioner submit that the petitioner was taken into judicial custody on 25/5/2018, and charge was framed on 26/12/2018. And even though more than 5 years have already passed since the date of framing charge, out of 152 or 157, what is the total number?
It was submitted by my learned senior that 152 witnesses,
Acha,
but the
out of
charge sheet reveals
one,
157.
out of 152 charge sheet witnesses who are supposed to be examined by the CBI, only 12 witnesses have been examined. The learned counsel for the petitioner further submitted that twice the petitioner has been granted interim bail for a period of 4 months.
4 months.
Once in BLAPL number
1022 of 2021.
1022 of 2021 as per order dated
16/11/2021.
16/11/2021, and
My lords, in BLAPL number 3722 of
and in
2022,
BLAPL number 3722 of 2022
by order dated 22/11/2022.
as per order dated 22/11/2022,
And it was extended.
which was extended in IN number 453 of 2023 as per order dated 21/3/2023 for a period of
2 months.
2 months. And after availing the bail period, he has surrendered at right time. And there is nothing against him that he has misutilized his liberty in any manner. The learned counsel for the petitioner produced the order sheet of the Learned Trial Court from 13/10/2023 onwards, which indicates that even though the case was posted after 13/10/2023 TO2 on 10/11/23 5/12/2023 12/12/2023 13/12/2023 2/1/2024 11/1/2024 18/1/2024 19/1/2024 30/1/2024 31/1/2024 15/2/2024 16/2/2024 1/3/2024 and 2/3/2024. But on 10/11/2023,
Two witnesses.
one witness देखो जी PW 10 बिलिंग
That must be correct. My lords.
One witness was examined, namely Smruti Ranjan Sahu as PW10. And the chief examination was deferred on the prayer of the Learned Public Prosecutor CBI. And then on 18/1/2024, one witness Tarun Kumar Saxena was examined, cross-examined and discharged. And on other date, no prosecution witnesses was produced.
My lords, the last date was yesterday. One witness who is charged sheet witness.
Mr. Panda Learned Counsel submits that the date was fixed on 18/3/2024 in the trial court, and one more
One
witness,
was examined.
that is PW12.
Yes, my lords.
PW12 was examined in the trial court.
Next
And-
date is 18th and 19th.
And therefore, there is inordinate delay on the part of the prosecution in cooperating with the trial court for for early disposal of the case. Mr. Nayak, Lenin, special public prosecutor, on the other hand, posed the prayer for bail and submitted that the case was instituted on KBLFR.
Yes, the FIR, the CBI FIR is in the year 2015 minutes.
The
Your Lordship may see the list of
3/9/2015.
list of
3/9/2015.
list of events again.
no bail, the 8646.
That the CBI case was instituted on 3/9/2015, and charge sheet was filed on 29/2018. And the petitioner was an absconder as per charge sheet.
Yeah, for 5 years he was absent.
The petitioner was an absconder as per charge sheet submitted.
Charge sheet, it's written that it's in judicial custody.
Charge sheet ହେଇଛି ପରା 20
ହେଇଛି ସେ
charge sheet ଆପଣଙ୍କର ହେଇଛି 20/9/2018.
ଆଜ୍ଞା charge sheet he is not an absconder, he is in custody.
ଆଉ କେମିତି ତାହେଲେ କହିଲେ 26/12/2018 ରେ ଚାର୍ଜ ଏଇ ଯୋଉ ଆଚ୍ଛା 25/5/2018 ଠିକ ଅଛି ତାହେଲେ ଦରକାର ନାହିଁ. Charge sheet was submitted on 29/2018, and after the lodging of the FIR, the petitioner was an absconder for number of years. Hello?
More than 5 years ago.
For 2004, for about 3 years. For about 3 years. Considering the submission made by the Learned Counsel, the Learned Counsel further submit that it's an heinous offense, and therefore he should not be released on bail. Considering the submission made by the Learned Counsel for the respective parties, since the prosecution, after the framing of the charge on 26/12/2018, the reason for delay disposal of the trial is not attributable to the petitioner in any manner, and it appears from the order sheet that it was on account of non-attendance of the prosecution witnesses. The case was adjourned from time to time, and since during the span of more than 5 years, the prosecution has examined only 12 witnesses out of 152 witnesses they are proposing to examine. And since there is nothing adverse against the conduct of the petitioner during the period of interim bail, granted by this court, I am inclined to release the petitioner on bail, subject to condition that he shall appear before the London trial court on each date when the case would be posted for trial, and he shall not try to come in contact with any prosecution witnesses or tamper with the evidence. He shall not indulge in any criminal activities, and he shall give his बाकी जो number of place of violation of any terms and condition, local surety he has to give in.
Passport,
Violation of any terms and conditions shall entail cancellation of bail.
passport, if any, may be surrendered.
I don't possess the passport. So
and one more thing, your lordships.
Passport, if any, to be deposited.
One more conditions.
Yes.
A good condition subject to your lordship's approval. Your lordships,
Yes.
most of the witnesses, after he absconded, some of the witnesses are outside Orissa. So if he goes there, one is in Indore, one is in Visakhapatnam, he may tamper.
I've said that if you get any trace that he's trying to influence, tamper anything, you can file a petition for the cancellation of bill. That order is very much.
But your lordships, you should not leave the territorial jurisdiction of Orissa in the meantime, your lordships.
No, if you get that any
But it will
witness.
be very, very difficult. Pan-India witnesses are there, your lordships. In Indore, Visakhapatnam.
Now you can take time. There he has been released on bail. You can take your time. There is no problem. But if you get any information that is misutilizing the liberty, you can call for the recall of that bail order. There is no problem. Yes.
Copy of the order.
Item 49.
May I please, your lordship?
Yes.
Petitioner is in custody for the offence 147, 148, 294, 341, 324, 307, 302.
You have received the case diary?
Well.
Is it your first application or earlier rejected?
First application.
First application. What is the date of custody?
Date of custody 13/3/2022.
13/3/2022. Charge sheet under section?
Charge sheet under section
147.
147.
148.
294. 341. 323.
Just go slowly. 341.
323.
Yes.
307. 302. 149 of IPC.
So who is that deceased?
Deceased is
T.
Somaria Reddy.
T. Somabira Reddy. Somabaria Reddy.
Somabaria.
Somabaria.
SAMBARIA.
BARIA. Reddy.
T. Somabaria Reddy.
And what is the date of occurrence?
Date of occurrence
21/10/2019.
21/10/2019. So that somebody else is injured for which 307 is there.
Yes, ma'am.
So who is that injured?
T.
Simancho Reddy.
T. Simanto Reddy.
Yes, ma'am.
So what he has stated about the overt act committed by this petitioner?
He assaulted the injured man. This person. He assaulted this injured person, my lord.
No, about the deceased.
Deceased who is married. Deceased who is married.
T. Srihari Reddy. T. Srihari Reddy.
I'm placing the statement.
He has been released on bail.
Just a minute. T. Srihari Reddy marla ku. Who marla deceased ku? Tentare.
Yes,
that is on what part of the body?
Chest.
Chest. That is the cause of death.
Yes, ma'am.
And so far as you are concerned, you assaulted T. Simanto Reddy.
Okay.
So what injury the T. Simanto has sustained?
Simple injury.
Simple injury.
Yes,
and is it correct that person, the co-accused who assaulted the deceased, has been released on bail?
That's what I don't know.
I have given Annexure 3.
Annexure 3. Mr.
Srihari
Tripathi, please verify. T. Srihari Reddy. He has filed the bail order copy. Case number 1415. नहीं नहीं आपनकर bail petition ne annex cheyichi pura annexure 3 paile. This is the bail order of BLAPL number 4316 of 2022. The name of the petitioner is T. Srihari Reddy, who is the main assailant so far as the deceased is concerned. All right. Are the learned counsel for the petitioner, learned counsel for the state. Learned counsel for the petitioner submitted that the petitioner is in judicial custody since 13/3/2022. He has been charge sheeted under section 147, 148, 294, 341, 323, 307, 302, 149 of the Indian Penal Code. The occurrence in question took place on 21/10/2019. And as for the statement of the injured, eyewitness T. Srimanto Reddy from
Simanchal Reddy.
Injured now T. Srimanchal Reddy. Acha, T. Srimanchal Reddy. The petitioner only assaulted him, but one co-accused T. Srihari Reddy assaulted the deceased T. Samabaria Reddy with a tenta on his chest, which resulted in his death. And the said T. Srihari Reddy has already been released on bail by this court in BLAPL number 4316 of 2022 as per order dated 14/10/2022. And therefore, in view of the nature of court act attributed against the petitioner, the bail application may be favorably considered. Learned counsel for the state placed the statement of T. Simanchal Reddy and fairly submitted that as per the injured statement, there is nothing against the petitioner to have assaulted the deceased. And the petitioner only assaulted the injured, T. Simanchal Reddy, and the medical examination report indicates that he has sustained simple injury. Considering the submission made by the learned counsel for the respective party, nature of overt act alleged against the petitioner, his period of detention in judicial custody, release of the co-accused on bail, I am inclined to release the petitioner on bail allowed appear before normal court.
Item 50.
Wait, please, my lords. My lords, I'm in custody since
Item 52.
taken on this. Data से साहू दे देवे এটা note please. Yes, Mr. Yes.
There is a delay of 13 days.
What is this criminal appeal for?
This is for appeal against acquittal by the victim. That there is a delay of 13 days in filing the
Notice has been issued.
Notice in delay matter has been issued, and
So what has happened?
the opposite court is on behalf of the accused. There is some appearance.
Yes, where is he? Gyanalok Mahanti.
Mahanti is not there.
All right, IA number so and so, miscase number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 13 days in filing this CRLA. After hearing the Land Council for the petitioner, Land Council for the state, the non-appears for the
If state
state
party, we have not received any copy.
state পক্ষে অଛନ୍ତି তো? Criminal appeal is an acquittal order. So give a copy.
Yes.
Uh,
Earlier, the revision was filed, my lord. Thereafter, it
Okay.
was converted into
But-
appeal.
ठीक है, जाओ copy दिन.
Yes.
Let an extra copy so and so. I'm inclined to condone the delay. Accordingly, delay is condoned, miscase is disposed of. Then what is this for? Let us see that. What is the judgment? What is the offenses? So you supply the, let us see.
I will supply and let it be
Let the
taken up for admission. my lord.
put up this matter in the week commencing from 2nd April 2024 for admission. Let an extra copy of the criminal appeal memo be supplied to the London Council for the state in the meantime. Do we chari 2024 for admission?
Week commencing 8, my lord. I pray.
All right, 8/4/2024 delay condone. Miscase disposed of. Yes, next.
Let the LCR be called for it. Will be
First के admission होगा कि नहीं देखिए तो आपरे. Yes, next.
Item 53.
Please, yours. This case, my lord, the substitution petition are allowed, my lord. Your lordship filed directed to file the consolidated appeal memo. I have filed consolidated cause title. Appellant has died. Wife has been substituted.
Consolidated cost title.
I have filed a consolidated cause title instead of consolidated appeal memo.
Order number 9 may kindly be perused.
Order number 9. Let a consolidated appeal memo. Appeal memo को ऐसा cost title कौन फाइल करिए? आपण एमिति लिख देले केमथि हो appellant सेमथि तो लिखा जायनी. एटा ये in place of so and so करी तार appellant रो ना रहिबो सेठी. You are not the person who has been, you are just continuing the appeal. Now you will mention like that. It is not that you have mentioned as if you are the appellant, you have faced trial and convicted. Your husband faced trial and he has been found guilty, right?
Yes, yes.
So your husband is dead. So you are taking the leave to continue the appeal. So the cost title should be something different, not in this way. So and so, wife of so and so, for so and so, the appellant. E type ro likha tha. Tapar appeal memo mane you have to file the entire thing. That is the order, not the cost title only. ହେଲା ସେଇଆକୁ ଆଉଥରେ type ହବ, but କାରଣ ଇଏଟା ରହିବ, one paper book would be prepared for that. This is necessary. Paper book ଟା जो prepare ହବ ବର୍ତ୍ତମାନ, जो consolidated appeal memo ଉପରେ paper book ଟା prepare ହବ. ତେଣୁ ଆପଣ cost title ରେ ଏମିତି ଦେଲେ କେମିତି ହବ? Okay. Had Mr. Mahanti Learning Council for the appellant and Mr. Sanjay Kumar Das, Learning Standing Council for the Vigilance Department. As per order dated 27 to 2024, the Learned Counsel for the appellant was directed to file a fresh consolidated appeal memo. But instead of that, he has filed consolidated cause title. The Learned Counsel for the appellant seeks some time to file the consolidated appeal memo, serving a copy thereof on the Learned Standing Counsel for the Vigilance Department within a period of 1 week. Khal type kariya katha tha kaun?
1 week.
Within a period of 1 week. Put up this matter on 2nd of April 2024. Yes.
Item 54.
A copy may be served on me, my lord.
Yes. Serving a copy on this one.
This copy has also cause title not served.
Okay, now this is not required because he has to give you a consolidated appeal memo.
Yes, my lord.
All right. Yes, what do you say?
My lord, petitioner in this case, my lord, acquitted from charges and the confiscation of the vehicle is under challenge, my lord. Last occasion, your lordship specific question to me, what is the status of the vehicle? Police has given a jibanama to me, my lord. And the second point, your lordship, the division of bench of judgment, where the Ashish Mahanti case is the for unclaimed vehicle. My lord, my case is that first Ishwar Satpathy judgment, my lord, in this case, the copy to us, copy and criminal appeal, copy. Receipt is there.
Report adi dekhi diyantu next week nahi hogi, है ना? As prayed for by Learned Counsel for the state submits that he has not received a copy of the appeal memo. Our Learned Counsel for the appellant submit that copy has already been served in AG office. Learned Counsel,
11. I will serve another copy.
Let a copy of the appeal memo be served on the Learned Counsel for the state by day after tomorrow. By day after tomorrow, put up this matter on 2nd April 2024.
Item 55.
Mr. R.N. Barik, Vishwa Prakash Dhar. अच्छा, non-appears करी अर्जन कर दूँ.
Status report मगाए
नाहती हो कौन करेगा? रखी था status report तो अच्छी हो.
नहीं, status lordship director का low report to keep.
No, status report is there, but the counsel is not there. So, yes.
Item 56.
Mr. Yes.
Mr. Pandana is omitted.
So,
Challenging the judgment and order dated 8/9/2026 passed by the learned court below.
What is the judgment?
Confirming the order of attachment of property dated 4/12/2024 by government matter.
So it is an OPID Act matter.
Yes, ma'am.
So have you given the copy to Mr. Vivekanand Bhuiya or Mr. Patro? They are the counsel. Have you served it on the state council, Mr. Tripathi?
Yes, I'm passing copy.
So you are to hand it over to the Mr. Patro, and I am reflecting the name of the Learned Counsel so that it would be easier. It appears that the order under challenge has been passed by the presiding officer designated court under the OPID Act, Qatar. Let the Learned Counsel for the appellant has served the copy of the appeal memo on the Learned State Counsel, who submits that he will hand over the copy to Mr. Vivekanand Bhuiya or Mr. J.P. Patro, who are the Learned Special Counsel for the state of Orissa in such matters. Put up this matter in the week commencing from 2nd April 2024, indicating the names of Mr. Vivekanand Bhuiya and Mr. J.P. Patro in the cause list. है ना?
Obliged, my lord.
Item 57.
May I please, Your Lordship? My lord, in this case, the conducting counsel
My lord,
has
I
ex-
am
Other item is Deepti Ranjan Bhokta knows nothing has been filed here. So, yes, next.
Item 60.
May I please read? On the last occasion, the custody certificate was called for that, and also regarding the conduct of the petition during interim
Yes,
bail.
कौन हला कौन?
And out of 10 years, earlier submitted 7 years, 6 months.
ଟିକେ ରୁହନ୍ତୁ। ଦିଟା ଜିନିଷ ଗୋଟେ ହଉଛି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଆଉ ଗୋଟେ ହଉଛି କଣ୍ଡକ୍ଟ।
Conduct as custody certificate.
Custody certificate ଆଣିଛନ୍ତି ନେଇ ଆସନ୍ତୁ conduct ଆର ସପ୍ତାହ Madam Counsel for the state has produced the custody certificate which is taken on record. However, he seeks some more time to obtain instruction about the conduct of the petitioner during the interim bail period. Hala? Put up this matter the week commencing from 2nd April 2024. Yes.
Item 61.
Item 61, my lord.
appearing, Mr. Miller. What is the delay?
Hello, for the COVID-19
280
pandemic.
days. So, what is your prayer in this criminal appeal? You are praying to set aside which order? 4/1/2020.
4/1/2020 passed by the OPID court. OPID court.
It was the rejection of your 457 CRPC petition.
Yes, ma'am.
So, any objection to the
copy में भी सर्व होना
which copy?
पिटिशन कॉपी अलग डिले कॉपी मिला
Deenadi.
नहीं
Please serve a copy of the appeal memo along with the interim application for condonation of delay.
Yes, ma'am.
Let the learned counsel for the appellant serve the copy of the appeal memo along with the interim application for condonation of delay on either Mr. Vivekanand Bhuya or Mr. J.P. Patra during course of during period of 1 week from today. Put up this matter in the week commencing from 2nd April 2024.
item 56 name of Mr. Bhuya मिलो
कोटा कहले
item 56 मिलो
56 कहली परा आपन ना आसीओ बोली एटा आपन को सी कॉपी हैंड ओवर next week. Yes, item 65, Mr. Rajiv. Yes.
IA 1482 over 2023 for interim bail matter.
Which one?
IA 1482. Appellant number 2. Instruction was sought.
On what ground you are seeking for interim bail?
Impediment of a wife matter.
So what instruction you have received?
We have sent it on 6th March, not yet gotten. It is outside Bihar Civil instruction.
अच्छा बाकी जो rest of the thing verify
Yes,
कीजिए.
yes, ma'am. I'm serving it.
So the address is all right.
नहीं, that part matter. The affidavit is genuine कि नहीं last order में थिला. That we have verified.
Affidavit means
Affidavit जो था actually कटक रे file करले whether it was genuine or not. That has been verified.
element of the wife of the petitioner number 2.
ସେଇଟା ଆମେ pray
That for that you want time.
Yes, sir.
One of the appellant has availed the interim bail period and he has absconded. So failed to surrender and NBW was issued. So what can be done? This is the conduct of you
I
are the
am not
counsel.
I am not the
You are the counsel and one man you have been
I am not
granted.
appellant for one man. I'm for appellant number 2, my lord.
Same thing. You have, this is the conduct. One man has gone and he was granted interim bail, not surrender. Already obtained instruction. The land counsel for the state seeks some more time to obtain instruction on this interim application. The IA number na 1842 of 23. Interim bail of appellant number 2. Say instruction time region urgent ko diyan. Yes, next.
Item 66.
Yeah, please, my lord. Item 66, my lord, pray for next week, my lord. In the meantime, my lord, we supplied a local security document, my lord.
Okay. No. You have already supplied or you will supply?
Supplied, man.
Okay. The learned counsel for the appellant submits that there was a direction, earlier direction.
Yes, sir.
That he is yet to supply the. No, he will supply the names, documents, and of the 2 local sureties who are interested to so and so for bail of the put of this matter on such and such date. If documents are supplied, instructions shall be obtained about the genuineness of the bailer and authenticity of the documents.
Item
Yes.
67.
May I please, Your Lordship? Lordship, appellant conviction and sentences to undergo RI for 10 years and fine 1 lakhs in default to undergo further RI for 2 years under section 20B2C NDPS Act, my lord. And my lord, the petitioner is in custody, my lord, 12, 11 to 19, my lord. More than 4 years, 4 months.
No, you have not completed 5 years of sentence. That would be the half of the sentence because so list this matter. କେତେ ହେଇଛି 4 ବର୍ଷ?
4 ବର୍ଷ 4 ମାସ.
Acha, put up this matter after summer vacation. Yes.
Item 68.
Pardon me. Previous item 68. Your Lordship, adjourned to after vacation. Kindly it be before vacation because the doctor has not supported. The victim changed her version time and again. Before vacation, any.
Item 69.
May I please, Your Lordship? I am appearing on
Item 70.
May the present petitioner convicted under section only 394 IPC, sentence of 5 years, and his custody near about 3 years, actually 2 years 11 months, and only that period.
Why 2 IA has been filed? Is there
Because
more
of
than
the it is a JCRL. As per instruction, he has.
Is it more than one appellant?
No. One appellant.
Then you have to not
double.
press one of them. Which one you want to not press? The earlier one, 18.
Yes, my lord.
All right, 18 of 23 for bail not pressed. So, what is your sentence? You said
5 years, my lord.
5 years, and you have been in custody for 3 years.
3 years.
Yes, what do you say?
Yes, hello, but only thing is that he has 3 criminal antecedents of stringent condition.
Are the learned counsel for the petitioner and counsel for the state?
One is 395.
Considering the submission made by the learned counsel for the petitioner, that out of 5 years of substantive sentence imposed by the learned trial court, the petitioner has already undergone 3 years of sentence.
5 years punished convicted. 3 years.
3 years.
Near about 2 years 11 months.
About 3 years of sentence. And hearing the learned counsel for the state who submits that the petitioner has got 2 criminal and 3 criminal antecedents.
PW 11 is stated in
I'm inclined to release the petitioner on bail, subject to condition that he shall not indulge in any criminal activity. In the absence of any chance of early hearing, he shall not indulge in and violation of any terms and conditions shall entail cancellation of bail and sterilization of fine. Yes.
Yes.
Item 71.
May it please your lordship? Your lordship, in this case, your lordship was pleased to release the appellant number 3 on interim bail on 14/11/2023 for a period of 2 months. Thereafter, your lordship was pleased to extend that period of interim bail for a period of 15 days on 11/1/24. Aggrieved by such, your lordship, the appellant had moved the Honorable Apex Court, and the Honorable Apex Court has been pleased to grant the appellant number 3 interim bail for a period of 6 weeks, your lordship.
Who has granted interim bail by me?
Yes.
That is
Appellant
appellant number 3.
Yes, your lordship.
So,
And directed.
just first, which date he was granted bail?
14/11/23, your lordship.
14/11/23.
Yes, your
For a period of
2 months.
Okay. Then
On 11/1/24, your lordship was pleased to extend the interim period for more 15 days, and he was to surrender on 1st February 24.
direction was to surrender on 1st February.
February 24.
Okay. So then he approached the Honorable Supreme Court.
Yes, your lordship.
And Honorable Supreme Court has
Extended 6 weeks. 6 weeks.
extended for 6 weeks.
And also directed to hear the regular bail.
Regular bail.
Now, which is that bail application? That is 612 of 23.
Your lordship, I request your lordship for an adjournment for the hearing of the bail application.
But that 6 weeks period may be over.
If I may pray your lordship to post the matter on 27th or 28th, your lordship, the conducting
Alright,
counsel will be appearing
the
from Delhi.
Learned counsel for the petitioner appellant has filed the order passed by the Honorable Supreme Court in so-and-so case number, which is taken on record, and further 6 for an adjournment till next week for the hearing of the interim application for bail. Put up this matter on 27th March.
Hearing of the regular bail application.
In hearing of the regular bail application, that is IA number 612 of 2033. So matter will be listed on 27th March. Yes, 8 application on record for this. Mr. Partha Sarathi Naik, Senior Panel Counsel for the Union of India is present. Yes.
Item 72.
Please, let's see. The appellant filed the modification order dated 27/2/2024. Your lordship was pleased to
Where is it
granted the interim bail for 3 months
27.
to 2024.
Where is that order?
And
Wait. Hmm, 27 to the order. Yes, sir. What modification you want?
instead of 2 CVT, 1 CVT. Because she is unable to, but 1 CVT did not agree to stand as CVT, my lord, for his personal difficulty. And petitioner's wife is, my lord, labor and out of state, my lord, so she is unable to produce another CVT, my lord.
He's an outsider. No?
Yes, my lord. The Melbourne 50,000 maybe state, maybe 1 lakh, and instead of 2 CVT, 1 CVT.
Acha. So, okay, he has instruction. Mr. Satpathy had already instruction of about those 2 securities.
Yes.
Okay, so you want that let that amount be increased, but the 1 security. What do you say?
Your lordship, please.
All right. So I'm making it 2 lakhs.
Yes, your lordship.
No, cash.
Your lordship, please.
2 lakhs 1 security. है ना?
Your lordship.
Like them. So after so and so going through so and so the
My lord, name may be deleted. One surety name may be deleted.
ଆପଣ ଗୋଟେ ତ security କାହାକୁ ଦେବାକୁ ଚାହିଁବେ?
Smriti Ranjan Sahu ko dabo.
Okay. The operative portion of the order dated 27/2/2024 is modified to the extent that instead of bail bond of rupees 50,000 with 2 local solvent sureties, if the petitioner furnishes bail bond of rupees 2 lakhs with 1 local solvent surety, that is of Smriti Ranjan Samadarshi,
Yes.
for the like amount to the satisfaction of the learned court in session over the matter, he shall be allowed to be released on interim bail
Date of release.
in pursuance of the order dated 27/2/2024. The rest part of the order remains unaltered.
Yes.
Urgent copy, my lord.
Yes, sir. 2 lakh 1 security.
Item 73 pass over mail.
हाँ
Pass over mail.
नहीं और दिन आज जी तो सब
Tomorrow no.
all instruction have come.
Yes.
Okay.
Tomorrow.
Day after tomorrow, 21st of March 2024. Yes. Next.
Item 74.
Yeah. Petitioner already
Yes. Okay,
Item 75.
I'm on VC, my lord. I'm on VC.
Yes.
There is an appeal filed by 5 persons who are the claimants who are claiming the amount seized by the police vigilance. The case was initiated against the accused and he was acquitted. But the land trial court has confiscated the amount that is seized from his possession. And these 5 persons have lodged their claim.
No, the registry has supplied you that interim application. Why?
No, I have not received the copy.
I have
No, I have not asked you. I have asked the registry. I supply him the copy of the I just now. What is the delay according to the SR?
SR is actually about 4 months probably.
No, it is 102 days delay. So you want to file any objection? If you can file.
My lord, my submission before your lordship that these appellants are strangers to the proceeding. Your lordship may kindly have a glance to the judgment.
That will be considered on merit. We are on delay condonation.
Oh, how delay condonation? How far these appellants are able to present this appeal? I am submitting that sentence only. Delay will be condoned if the appellants have any case before your lordship.
No, not.
I am submitting that only.
I may dismiss the appeal on merit, but or on at the admission stage. But
I only pray before your lordship to have a glance to the judgment. Page 1.
Honestly, unless suppose delay is not condoned, if I am not satisfied with the explanation given for condonation of delay,
Yes,
then I can dismiss the criminal appeal interim
Yes,
application. So
my lord, I will file objection regarding the strangers filing an appeal.
Give an appeal.
I will file my objection.
All right. The Learned Counsel for the Standing Counsel for the Vigilance Department submitted that in spite of the order dated 12/3/2024, he has not been supplied with the copy of the interim application. That is the IN number 543 of 2024. Let a copy be. Acha, लिखी दूँगी copy supply है लेवल. The copy of the IN number so and so is supplied to him in court today, who seeks some time to go through this same and file objection, if any, to such I. The Mr. T.G. and Murthy Land Council.
N. Murthy
Land Council appearing through virtual High Court, CORAM at Jaipur is present. The put of this matter on 2nd April.
नहीं 15-16 ବେଳକୁ ଥାଉ ମୁଁ ଡାକିବି ଆଇଓଙ୍କୁ ତାଙ୍କୁ କୋରାପୁଟରୁ ଆସିକି
All right. Put of this
16 ବେଳକୁ
it commencing from 15th of April 2024. Objection, if any, be filed in the meantime, giving copy to the Learned Counsel for the appellant. Yes. So, Mr. Murthy, it will come in 15th April 2024.
Yes, my lord. Very much.
Today's copies, ma'am. Yes, free copy of the order 300 over. Yes. Yes, next.
Item 76.
May I please? Last occasion, my lord directed the State Council to take instruction if any pregnancy of the victim.
When a query is made to Learned Counsel about the status of pregnancy of the victim, he seeks some time to obtain instruction. Oh, the evidence was that he was pregnant. What happened?
He gave birth to a boy child, male child.
Okay, and what is his present status?
He is residing with the parents.
City Hospital, Kotak. His name is Swanson. He's reading and on the victim with father's place. So now, what is your instruction? You are a married person.
Yes.
Item 80.
Yes, Mr. Jena.
So out of 7 years sentence,
What is the offense here?
seizure for part 2 conviction errors.
Uh,
Sentence 7 years. And I am
Yes, sir.
already remaining custody 4 years now.
Kodu janiva.
Date of custody is also 10 to 2020.
Bail le thilegi.
No.
Huh?
No.
କି ଜଣା ପଡୁନି ଏଥିରେ କଷ୍ଟଡି ଦେବା କଥା ସେ ଫର୍ମାଟ ଟା ଦେଇନାହାନ୍ତି ଫର୍ମ ବି ଟାରେ ଗୋଟେ
ଲାଷ୍ଟ ପେଜରେ ଅଛି
ଲାଷ୍ଟ ପେଜ
ହିୟରିଂ ଅଫ ସେଣ୍ଟେନ୍ସ ପରେ
ଆଚ୍ଛା ଦେଖିବା ପେଜ କେତେ କହିଲେ
ପେଜିଂ ହେଇନି
ହଁ ଓ ସେଠି କଣ କହିବ ଆଚ୍ଛା this man is okay Ravindra Singh. So 10 to 2020 Mr. Jena so kete lag 4 years 4 years and of course 4 years 1 month here and kete sentence is 7 years. All right, hard the learning counsel for the petition learning counsel for this since the petitioner has already undergone 4 years 1 month of sentence out of 7 years of sentence imposed by the trial court and there is no chance of early hearing. I'm inclined to release the petitioner on bail allowed. Yes.
Item 81.
81, Mr. Tripathi.
I'm the VC man. Right. This is an appeal against the conviction, Your Lordship. At page 20.
Item 82.
I have a small submission, beg your pardon. It is a conviction under section 376D, Your Lordship. Whether notice is required to the victim.
It is DA by notice, sir. DA. Yes, D by notice. Yes.
Published.
Earlier, my lord, this criminal appeal is disposed of directing the petitioner to raise all the points from the court below. Thereafter, I have come. Earlier, the criminal appeal has been disposed of by this honorable court and directing the petitioner to raise all the points from the court below.
Where is that order? The earlier order you are mentioning.
Already page 2 mention is.
Page 2.
Page
2 of the impugned order.
My lord. Annexure 2, sir.
Annexure 2.
Annexure 2.
What was your application for?
Application was release of vehicle.
Okay. So, when that order was passed?
Order was passed on 8/3/2017.
Please come to the page number, annexure to page 10. The application is dated 17/12/2018. So how did you say that it is the date is 21/1/2019? So that was the order passed. So you prayed for release of a seized vehicle in your favor, right?
Mine.
So then you approached this court earlier in another CRLA, and this court has disposed of with an observation that you are at liberty to
To
raise the contention that your property is not liable for confiscation before the presiding officer designated court under the OPID Act in the proceeding for confiscation, and if such contention is read, same shall be addressed in proper perspective. Then the special PP submitted that adjudication of the present application filed so and so is governed by Section 9 of the OPID Act. Where is the OPID Act? According to him, a proceeding under Section 4(3) of the OPID Act was filed by the complainant. The above confiscation proceeding already disposed of terms of this so and so, and the order of so and so seized vehicle has been made absolute so and to sell them and for distribution of the victim. The present person was arrayed as opposite party, therefore submitted no more matter no. So he is right. After the order was made absolute, so you are to challenge the order under Section 13 of the OPID Act. How can you file an application for release? There was
Yes, I have filed the appeal 13 of the OPID Act. Yes, I'm filed an application.
Challenging that order in which it was made absolute, that ad interim attachment order was made absolute or not?
Yes, absolute, my lord.
So if it is made absolute, the option lies with you to challenge it in the appeal under Section 13. Please come to that.
13.
First, you come to Section 9. You see, first you come to Section 3, where it deals with ad interim order of attaching the property. Have you got that OPID Act with you?
Yes.
See that. Section 3 deals with ad interim order of attachment of the property. Okay.
Yes.
And that is to be passed by the government. Then the government would appoint so and so as the competent authority. Then the competent authority, what he has to do, now he shall apply before the designated court for making the ad interim attachment absolute for direction of. Then thereafter the procedure has been laid that once this sort of application has been filed, then what procedure has to be followed. And ultimately, the court has to decide whether that ad interim order of attachment is to be made final or not. Okay. So then the power of the designated court has been mentioned in Section 9 of that OPID Act. So there he said that what he has to do upon receiving the application under Section 4, and then how he has to hear both the parties. And then subsection 6 of Section 9 indicates that either he has to make the ad interim order of attachment absolute or vary it by releasing the portion of the property or the entire property, whatever it may be. So this order has already been passed. This 9(6) order has been passed, and that add-on interim order of attachment has been made absolute, right?
Yes.
So now, if this order has been passed, then you are to file an appeal under section 13 of the Act. So that is how it is stated that any person, including the competent authority, if aggrieved by an order of the designated court, may prefer an appeal. So after this provision is there is nothing that the property is to be uh, released in your favor by invoking the power under section 457 CRPC. So it is totally a different proceeding. CRPC, it deals with general procedure, but this is a special act, right?
Yes.
And the special act indicate that what procedure has to be followed before making the ad interim order of attachment final. That order has been passed. So if you are aggrieved by that order on for any reason, then you are to file an appeal under section 13. So without filing an appeal, you filed a petition for under section 457 CRPC. So that is the problem. So you are to better you file an application under section 13, and of course the period of delay would be there 30 days, because the appeal period is 30 days.
30 days.
And you can assign the reason, file an application for condonation of delay that can be entertained or not, that is to be decided. Okay. The learned counsel for the appellant intends to withdraw this appeal for challenging, for filing an appeal under section 13 of the OPID Act, challenging the order of the learned presiding officer designated court OPID Act Cuttack in making ad interim attachment of the seized vehicle absolute under section 9(6) of the OPID Act. Accordingly, the sworn, so Mr. Patra is present. The CRLA is accordingly disposed of.